Good morning.
Morning.
We're here on case number 14-18320, Corda versus the City of Miami and Penelope Township. The lawyers, please announce your presence.
Good morning, Your Honor. Alan Diamond, with me is Tim Kalaya. Together we represent Bayside Marketplace LLC.
Raul Cantero, Marketplace, and Julie Cardenas for the Southwest City Scholars.
Good morning, Your Honor. Warren Rosenthal, Assistant County Attorney on behalf of Supervisor Thomas.
Good morning, Your Honor. Warren Fisher and Forest Amherst for the City of Miami.
Olson?
Olson.
Good morning, Your Honor. Charles Corda, the plaintiff in the case.
Okay. Mr. Corda, anybody else? Mr. Corda, I have read the intervener's motions, and I've read your response. Have you anything further to add to your response?
Further, no, Your Honor, I think I can elaborate on it, or...
Well, if it's new, I'll listen to it. If you just want to tell me what you wrote, I don't need to do that.
Well, I'd like, if possible, to rebut what I hear. I'll save that.
Okay, you did. You did by filing this response, is that correct?
Yes.
Okay, the motion for intervention is granted. Okay, next item of business. I have reviewed your motion and your petition, Mr. Porter. I believe that the law is clear that I have to deny your motion. Do you have anything to add besides what you wrote?
In the original pleading, Your Honor?
Yes.
At this time,
Okay. All right, let me, I understand that time is of the essence here because you're going to have an August 26th
right.
vote, and whoever loses here is going to go to the DCA. So let me read what I have found. Mr. Porter argues that this ballot question is improper because it combines two or more separate and distinct subjects within a single referendum question, i.e. the extension of the Bayside lease and the construction of skyrise company within Bayside's premises. Corda also alleges that the ballot question does not provide enough information about the skyrise power for the voting public to make an informed decision on whether this structure should be approved. Finally, Corda claims that the ballot question contains monetary figures which are either misleading or outright false. As such, Corda has filed this petition for declaratory and injunctive relief, which prays this court to strike the ballot question from the upcoming August 26, 2014 special election / referendum, and further enjoin Miami and Miami-Dade County Supervisor of Elections from combining these two questions at any time in the future. For the reason stated below, this court declines the petitioner's request. Conclusions of law. As to the declaratory judgment, the Florida Declaratory Judgment Act is remedial in nature and should be broadly construed. However, in order to properly invoke the jurisdiction of the circuit court, a party seeking declaratory relief must not only show that he or she is in doubt as to the existence or non-existence of some right or status, but also that there is a bona fide, actual, present, and practical need for the declaration. Here, Corda argues that there is a bona fide need for a declaration as it relates to the upcoming ballot question. More specifically, the petitioner claims the referendum question as written is deficient because if a Miami resident wishes to approve a lease extension and necessary improvements to Bayside, he or she will also be casting a vote for the construction of a highly controversial, physically distinct, separately owned and operated 1,000-foot tall observation / amusement tower on city-owned waterfront land, even if he or she does not wish to do so. And that's at your petition, page 3. The August 26, 2014 ballot question. As a general rule, courts will not interfere with the democratic process to restrain the holding of an election. A court must act with extreme care, caution, and restraint before removing an amendment from the vote of the people. However, the ballot question must give fair notice of the decision the voter must make. In this case, the constituents of Miami must be able to comprehend the sweep of each proposal from a fair notification in the ballot proposition itself that is neither less nor more extensive than it appears to be. Furthermore, Section 101.1611, Florida Statutes 2013, required that a ballot question must set forth the substance of the public measure in clear and unambiguous language, which contains the chief purpose of the measure. The ballot, however, need not explain in every detail or ramification of the proposed amendment. In the case at bar, this court finds that the language in the proposed ballot question complies with the minimum required set forth by Section 101.161 Florida statutes. Corda argues the ballot question is invalid because it contains two or more separate and distinct propositions to be voted on, which, when commingled in one ballot question, prevents the voter from assessing each initiative independently and therefore prevents the voter from casting an independent vote for each initiative. This court respectfully disagrees and finds that the ballot question does not contain separate and distinct issues to be voted on by the public. As stated previously, the ballot question asks whether the voting public wishes to 1. Extend the Bayside lease, 2. Authorize the incorporation of a sublease within the amended Bayside lease, and 3. Authorize the construction of the skyrise tower to be located within the Bayside premises. The court concludes that the public cannot authorize the construction of the skyrise tower without first approving the modification of the Bayside lease. The issues are not separate and distinct, and thus the court finds that the ballot question as written does not violate Florida statute, nor does it violate case law. Furthermore, even though Corda raises concerns about the lack of specificity on several aspects of this deal, this court finds that the ballot question need not explain every detail or ramification in order for the voting public to make an informed decision on whether the referendum question should receive a yes or no vote. Finally, the court declines to address the allegations that the ballot question contains misleading or otherwise false financial figures, since the record contains no evidence to support or refute such claims. And in conclusion, the August 26, 2014 ballot question asking the voting public to 1. Extend the Bayside lease agreement, 2. Amend the Bayside lease agreement to include provisions for a sublease, and 3. Authorize the construction of skyrise tower contained within the Bayside premises comports with both statute and case law, and the court therefore declines to strike the ballot question. Okay, so your next step is to appeal if that's what you want.
Thanks.
Gentlemen, anything from you?
Thank you, Your Honor.
Thank you, Your Honor.
Okay, copies of the order, you can get them, I get about 5 minutes in my team.
Okay.
Thank you.